I, Judge Roman, do solemnly swear
I, Judge Roman, do solemnly swear
that I have not directly or indirectly paid,
that I have not directly or indirectly paid,
offered,
offered,
promised to pay,
promised to pay,
contributed, or promised to contribute any money or thing of value,
contribute or promised to contribute any money or thing of value,
or promised any public office or employment
or promised any public office or employment,
as a reward to secure your appointment or confirmation thereof.
as a reward to secure my appointment or confirmation thereof.
So help me God.
So help me God.
Municipal judges are public officials who are either elected or appointed to administer laws in cities. After swearing to an anti-bribery statement and taking the oath of office, judges can officially perform the duties of office. Municipal judges derive their authority from the Texas Constitution, statutes, and their city's charter and ordinances. One who accepts the position of judge accepts an obligation to exercise judicial authority in a manner that promotes public confidence in the judiciary. Although municipal judges work with other members or officers of the city, they still must adhere to the principle of an independent judiciary. This is the concept of separation of powers envisioned by both the United States and Texas constitutions. The court is the independent, third party that makes a decision based on applicable law. Like all judges, municipal judges must adhere to ethical standards required by the Texas Code of Judicial Conduct. The code emphasizes the necessity of the judiciary being independent and not allowing anyone to influence conduct or judgment. In all activities, the code requires judges to establish, maintain, and enforce high standards of conduct so that they avoid even the appearance of impropriety. The State Commission on Judicial Conduct, which investigates allegations of judicial misconduct and disciplines judges, issues public policy statements intended to help preserve the integrity of Texas judges. These public statements address issues such as judges not being able to serve the public as both judge and law enforcement, because this would undermine the public's confidence in an impartial and independent judiciary. Now let's look at municipal court jurisdiction. Municipal judges exercise their authority within the jurisdiction provided by statute. Municipal court jurisdiction to hear cases involves fine-only offenses that occur within the territorial limits of the city or on property owned by the city in the city's extraterritorial jurisdiction. Fine-only offenses are ones punishable by a fine and may also include other sanctions that are rehabilitative or remedial in nature but do not consist of jail or imprisonment. Next, we will look at judicial duties, which are ones that require the exercise of judgment involving questions of law, or in the instance of no jury, questions of fact. Also, judges can determine sentencing options allowed by statute. Judges have the discretion and the power to interpret and apply law guided by the rules of law. Because judicial duties involve issues of law, they must be performed by a judge and cannot be delegated. Even if a judge is part-time and not available to handle the day-to-day operation of the court, the judge may not delegate any judicial duty to a clerk or anyone else. To better understand a judge's duties, let's look at some specific ones. Judges admit persons to bail, request and accept pleas, conduct pretrials in which they rule on motions. They also conduct trials. Judges render and sign judgments. They determine the amount of fines and how defendants pay their fines. If a defendant has been in jail, the judge must give the defendant jail credit on his or her fine. If a defendant fails to pay a fine, a judge enforces the judgment by issuing a capias pro fine. Before issuing a warrant of arrest, capias, or summons, judges must determine probable cause. When defendants fail to appear, judges declare a bail forfeiture, which initiates the process of forfeiting the bond. Judges conduct stolen or seized property hearings and dangerous dog hearings. They grant driving safety courses and deferred disposition. When it comes to dismissal authority, a judge's authority is limited. except in a few instances that we will discuss later in this video. Being a judge also means overseeing the administration of the court. The Texas Code of Judicial Conduct requires judges to diligently and promptly discharge administrative responsibilities and to cooperate with other judges and court staff. Although judges can perform ministerial and administrative duties, typically they delegate these duties to a clerk. Ministerial duties are those duties that do not require any legal judgment or discretion and are generally administrative in nature. Some examples of these duties are preparing and maintaining the docket, receiving and depositing fines, court costs, and fees, preparing judgments for a judge's signature, maintaining and destroying records, scheduling cases for trial, issuing subpoenas, preparing state and city reports, explaining court procedures to defendants, delivering case documents to the appellate court when a case is appealed, and managing the clerk's office. One of the most important things that judges should remember in overseeing court staff and the administration of the court is that the Code of Judicial Conduct directs judges to require the court staff to observe the standards of fidelity and diligence that apply to the judge. Now let's visit a court to see a judge conducting an arraignment, which is the process where a judge identifies the defendant and requests a plea. After being arrested on a charge of public intoxication, the defendant is brought to court from jail.
You are Angela Baumgarten.
Yes, Your Honor.
You're charged with the offense of public intoxication. You can plead guilty, nolo contendere, which is no contest, or not guilty. If you plead guilty or nolo contendere, I will set a fine. If you plead not guilty, I may set a bond and schedule you for trial. Do you understand the pleas?
Yes.
How do you want to plead?
Guilty, Your Honor.
Before I set your fine, are there any circumstances regarding your case that you'd like to tell the court?
No.
Only a judge can request a plea from a defendant and set the fine. If a defendant refuses to give the court a plea, the judge must enter a not guilty plea for the defendant and set the case for a jury trial. If the defendant has been in jail, the judge, upon conviction, must give jail credit for each case that the defendant spent time in jail. Some defendants, upon pronouncement of the amount of fine, indicate that he or she is indigent. The judge must then conduct an indigent hearing to determine the defendant's ability to pay the fine. Let's see how a judge handles this.
You have pled guilty to the offense of public intoxication. The fine, along with costs, is $150.
I really can't afford that, Your Honor. I don't have any money. I really can't pay that.
Okay, then I need you to complete this financial information form, and after you've completed it, come back in.
Thank you, Your Honor.
After the defendant completes the form, the judge will ask the defendant to swear that the information contained in the statement is true and correct. Then the judge will place the defendant under oath and ask the defendant questions about the financial information that he or she has provided the court. Another instance in which a judge might have to conduct an indigent hearing is when a defendant has been arrested on a capias pro fine for failure to pay a fine. During this hearing, the judge must determine the defendant's ability to pay, whether the defendant willfully refused to pay or if the defendant failed to make a sufficient, bona fide effort to legally acquire the resources to pay. Anytime that a judge determines that the defendant is indigent, the judge can allow the defendant to pay the fine in installments or require that the fine be discharged by community service. However, if community service works a hardship on the indigent defendant who defaults on payment of the fine, the judge may waive the fine and costs. The one thing that a judge cannot do is commit indigent defendants to jail simply because they are unable to pay. But if a defendant who defaults on payment of a fine and/or costs is not indigent and refuses to pay the judgment, the court can specify in the judgment a period of time of not less than 8 hours or more than 24 hours as the period for which a defendant must remain in jail to satisfy $100 of the fine and costs. Next, we see a judge conducting a jury trial. Municipal judges have the authority to preside over jury trials and non-jury trials, commonly called bench trials. The judge can also require defendants and the state to appear for a pre-trial hearing, which is conducted to consider motions, issues, or matters that do not pertain to the merits of a case. Now for the jury trial.
All rise. City of Midway Municipal Court, Liberty County, Texas, now in session. The Honorable Catherine Davis presiding. Please be seated.
Ladies and gentlemen, welcome to the Midway Municipal Court. You have been called for jury duty and will be examined for inclusion in a jury hearing a criminal case.
At the start of a jury trial, the judge welcomes the prospective jurors, which is called the array. The judge explains the role of the jury, gives information and instructions about the jury trial process, and administers or causes to be administered an oath to the array. The judge then explains the statutory requirements to be a juror and questions the array to make sure that each person is qualified to sit as a juror. The judge also determines if anyone wishes to claim a legal exemption from jury duty. After qualifying the array, the judge announces the case, introduces the lawyers and the defendant. The judge then explains the duty of jurors, the role of the judge, and gives instructions to each juror to follow throughout the trial. During this explanation, the judge emphasizes the importance of a fair trial. Now both the defendant and state can question the array, with the state proceeding first. This questioning is called voir dire. It is at this time that if either side feels that a prospective juror is biased, the person may be challenged. The judge calls the person before the bench to determine if he or she can be impartial. After all challenges, a 6-member panel is selected. These 6 jurors must take another oath administered by the judge or under his or her direction. Now the judge directs the prosecutor to read the complaint, unless the defendant has waived the reading. Then the judge takes a plea from the defendant. Also, witnesses are identified and sworn. Before the presentation of the evidence, both the state and the defense can make opening statements. The state may make the first statement. If it does, then the defense can make a statement unless he or she chooses to wait until the prosecution presents its case in chief and the defense presents evidence. During the trial process, the judge administers an oath to witnesses, presides over the conduct of the trial, rules on questions of law, and maintains order and decorum in the courtroom. After all the evidence is presented, the judge charges the jury, and then both sides present argument for their respective cases. After argument, the case is submitted to the jury. If the verdict is not guilty, the judge renders a not guilty judgment, dismisses the case, and discharges the defendant of any liability. If the verdict is guilty, the judge renders judgment and imposes a fine and costs. The defendant may pay the fine, make a motion for new trial, or appeal. Defendants have a right to a jury trial and must waive that right in writing if they do not want one. When a defendant waives a jury, the judge hears the evidence, decides questions of law, and renders judgment based on the evidence presented and the laws that apply to the case. Although defendants have a right to a trial, many defendants choose not to contest the charges against them. These defendants choose to waive a jury trial and plead guilty or nolo contendere in open court, by mail or by delivering the plea and waiver to the court. In non-record municipal courts, defendants may also appeal after a plea of guilty or nolo contendere. Let's see how a judge handles mail-in payments and payments delivered to the court.
Judge Roman, here are the payments that I received yesterday. These came through the mail and these were delivered to the court.
Thanks, Nancy. Do you have the paperwork that goes along with the file so that I can review them? And are the judgments prepared as well?
Yes, sir. I have attached the receipt to the fine payment. I do believe that everything is in order.
Although clerks receive and process pleas and fine payments, only a judge may accept the plea, waiver of jury trial, and fine amount offered by the defendant, and upon acceptance, enter judgment. Because the judgment is just one of many documents that a judge must sign, some judges use a signature stamp. Judges frequently ask whether they may direct someone else to sign by using his or her signature stamp. The Texas Attorney General addressed that issue in Opinion JM 373, which says that a signature stamp can be used by another person as long as the person does so in the presence of and at the direction of the person whose signature is being stamped. This concludes Part 1 of Authority and Duties. To begin Part 2 of Authority and Duties, let's see a judge granting deferred disposition.
Mr. Holmes, you are charged with failure to maintain financial responsibility. If you had a valid automobile insurance at the time you received your ticket, the court, after verifying proof of insurance, will dismiss the case. The verified proof is a defense to the prosecution. How do you want to plea?
I was hoping you could drop the case. I didn't have insurance.
I can't hear the facts of the case without a plea. If you had valid insurance at the time you received your ticket, the court will receive that evidence. Otherwise, I must have a plea of guilty or nolo contendere, which is no contest, before listening to any facts of the case. If you wish to plead not guilty, I will schedule you for trial.
All right, I plead no contest. I didn't have insurance when I got the ticket, but I have purchased it, and I brought the insurance card with me to show you. I'd hoped you would take that into account and maybe drop the ticket.
I don't have the authority to dismiss your case since you didn't have insurance on the day you received your citation. However, I can grant deferred disposition, which is a type of probation. If you decide you want deferred, I'll put you on probation for 180 days and require you to keep insurance during that time. At the end of the 180 days you have maintained the insurance, then I will dismiss the case.
Okay, how much would that cost me?
You must pay court costs before I grant deferred, and this is the same amount you would pay if you were convicted. Then at the end of the deferral period, you'll have to pay a special expense fee that will not exceed the amount of fine that I'll set when I grant the deferred. Do you want to agree to deferred disposition?
Yes, Your Honor. Thank you. I don't want this in my driving record.
In this case, the judge decided that placing the defendant on deferred disposition was better than imposing a fine. Granting deferred disposition is discretionary with the judge, but the defendant must also agree. If a defendant completes the terms of deferred disposition, the judge is required to dismiss the case. Let's talk about a judge's authority to dismiss. This power is limited absent specific authority to dismiss. If there is no statutory authority, a judge must have a prosecutor motion requesting the dismissal of a case. As you have just seen, when a court grants deferred disposition and the defendant complies with the terms of the deferral, the court must dismiss the charges. Other procedures that require dismissal are when a defendant completes a driving safety course or the terms of a teen court. If a defendant had valid insurance and the court verifies the evidence, the judge must dismiss. Or if a defendant had a valid driver's license at the time a citation was issued for failure to display a driver's license or no driver's license, the court must dismiss the charge when the defendant presents the valid driver's license to the court. A judge must also dismiss a charge of expired registration if the registration is expired less than 60 days and the defendant gets valid registration within 10 working days of receiving the citation. The judge is also required to assess a $10 fee upon dismissal of the registration charge. Other instances when a judge must dismiss include when a judge determines that he or she does not have jurisdiction of a case, or that a defendant's speedy trial has been denied when the defendant has presented a motion to the court. Similarly, on a motion to quash, which means that the defendant is asking the court to set aside a complaint because it is defective, the judge must dismiss the charge if the complaint is defective. Judges do have discretion, although not a legal duty, to dismiss charges without a prosecutor's motion for 3 offenses. They are: expired registration that is expired more than 60 days, expired driver's license, and expired inspection certificate. A judge may dismiss these charges after defendants remedy the delinquency within 10 working days of receiving a citation and present proof of compliance to the court. The judge may also impose a $10 fee upon dismissal. Now we will take a closer look at a judge issuing warrants of arrest.
Judge Ronan, I have pulled the case files of defendants who failed to appear, and I have prepared warrants for your signature.
Okay, do each of these cases have a probable cause affidavit for me to review?
Officer Hill is in my office, and he's finishing his probable cause statements on the original offenses. I've already prepared mine for failure to appear charges.
Okay, please have Officer Hill come in. Will you both raise your right hand, please? Do you both swear that the information contained in these statements are true and correct?
I do.
Please sign your statements and leave them with the case file so that I can review them.
If a judge determines that there is probable cause, he or she may issue a warrant of arrest. Usually a judge issues a warrant of arrest when a defendant fails to appear or is not in custody when charges are filed. If a defendant fails to appear, a separate charge of failure to appear can be filed and prosecuted. If the offense charged is a violation of a city ordinance, typically a judge will issue a summons first, before issuing a warrant. A summons notifies the defendant of charges filed and gives the defendant a date and time to appear in court. Although a summons does not arrest a defendant, if ignored, it is enforced by a capias, or a warrant of arrest, which requires probable cause. Hence, the court should have probable cause before issuing the summons. Also, before a judge can issue a summons, a prosecutor must request the issuance. Sometimes, a defendant fails to pay a fine. When this happens, the judge can issue a capias pro fine for the amount of the judgment owed. Probable cause is not required, but a judge must have sufficient facts regarding the non-payment of the judgment before issuing a capias pro fine. Although we have discussed many judicial duties in this video, there is not enough time to describe in detail every judicial duty. However, it is important for judges to know that the Code of Judicial Conduct requires judges to be knowledgeable in the law. Judges should understand that any duty that is judicial is a special grant of authority and discretion and cannot be delegated. It is judicial authority that allows courts to make decisions and judgments. It is a power that must be guided by rules and principles of law, because judicial discretion is not arbitrary, capricious, or unrestrained. Next, we will look at magistrate duties. All Texas judges are magistrates. Being a magistrate is additional power and authority. While a municipal judge's authority is limited to the territorial limits of a city and property owned by the city in the city's extraterritorial jurisdiction, magistrates have authority within the county or counties in which their city is situated. Magistrate duties are broad and are scattered throughout the Code of Criminal Procedure and other codes. Generally, a magistrate has authority to issue search warrants and order arrests for Class A and B misdemeanors and felonies. They can advise an accused of constitutional and statutory rights and set bond. Magistrates may arraign a defendant charged with a fine-only offense when the defendant has been arrested on an out-of-county warrant. This means the magistrate may take a plea, set the fine, and grant jail credit. The magistrate must return to the court of jurisdiction the plea, any fine payment, and all orders within 11 days of the arraignment. Magistrates can issue emergency protective orders and emergency mental commitments. They can also conduct examining trials, which is to determine probable cause in the case of a felony. And magistrates can conduct some administrative hearings involving license suspensions. Like judges, magistrates are required to be neutral and detached, taking a fair and impartial view when assessing probable cause. This is especially important when magistrates assess facts to determine if there is probable cause to issue a search warrant. Generally, a municipal court judge acting as a magistrate has authority to issue search warrants, except a search warrant for mere evidence. As a general rule, only municipal judges sitting in a court of record may sign evidentiary search warrants. That is, search warrants ordering seizure of non-contraband items. Now we will see a judge acting in his or her capacity as a magistrate.
Judge Roman, I've just finished a forgery investigation, and I have my paperwork here for you to look at. Here is the probable cause affidavit right here.
Please raise your right hand. Do you swear the information that is contained in these documents is true and correct?
I do.
Let me read through the information. It's going to take me a few minutes, and you can wait, or I can call you when I decide whether or not to issue this warrant.
I'll wait.
Please, go ahead. You can wait in my clerk's office.
Thank you.
In this case, the offense, forgery involving a credit card, is a state jail felony. The judge has authority as a magistrate to accept the complaint, determine probable cause, and issue the warrant. The case will eventually be transferred to the district court, which has jurisdiction to hear it, but until the defendant is indicted, the magistrate has authority over the case. Next, we see a municipal court judge performing the magistrate duty of reading and explaining a defendant her rights. The defendant has been arrested on the warrant for forgery.
Miss Caulfield, an affidavit has been filed with me charging you with the offense of forgery of a credit card, which is a state jail felony offense punishable by confinement in a state jail for a term of not more than 2 years or less than 180 days, and a fine not to exceed $10,000 may also be assessed. Now I'm going to explain to you your constitutional and statutory rights. You have the right to hire an attorney to represent you. You have the right to have an attorney present prior to and during any interview and questioning by peace officers or attorney representing the state. You have the right to remain silent. You are not required to make a statement, and any statement you make can and will be used against you in court. You have the right to stop any interview or questioning at any time. You have the right to have an examining trial. You have the right to request appointment of counsel if you cannot afford counsel.
When a person is arrested and brought before a magistrate, the magistrate must take care to ensure that the defendant actually understands his or her rights, as well as how those rights work. If a magistrate has been designated by either the local county or district judge as having authority to appoint counsel for an indigent defendant, the magistrate will proceed to do so. If a magistrate has not been designated to appoint counsel, then a magistrate's responsibility to the accused is fulfilled by immediately forwarding a request for appointment of counsel to the authority designated in the county. Because this case is one that a municipal court judge has no authority to try, the magistrate will not take the plea, but will just set the bond.
Do you understand the rights I've just explained to you?
Yes, I do.
Okay. I'm setting your bond at $5,000.
This is another time that a judge may have to consider indigence. If the defendant claims to be indigent, the magistrate will have to determine the defendant's ability to post bond. The magistrate may have to consider lowering the amount of the bond or releasing the defendant on a personal bond. Also, if a magistrate determines that a defendant is mentally ill or mentally retarded, the magistrate must order an examination of the defendant by the local mental health or mental retardation authority, or by a disinterested expert experienced and qualified in mental health or mental retardation. Because the duties and responsibilities of a magistrate greatly add to the power and responsibility of a judge, municipal court judges should be careful not to be a rubber stamp for city government. Judges must take time to understand the law and standards of conduct regarding municipal judges and magistrates. At first, being a municipal judge may seem overwhelming. It helps to become familiar with the Code of Judicial Conduct and the laws that govern the procedures and practices in municipal court. The Texas Municipal Courts Education Center and the many judges who are on its faculty are always willing to assist new judges. All you have to do is call. The preamble of the Code of Judicial Conduct provides, that our legal system is based on the principle that an independent, fair, and competent judiciary will interpret and apply the laws that govern us. In other words, justice depends on the judge.